Hello everyone, and welcome to our fourth bite-sized learning module we're filming as part of our Modern Slavery Impact Initiative. These are a series of conversations we're having with leading experts throughout Australia, unpacking key modern slavery risk issues for Australian businesses. And this series has been made possible as part of the Australian Government National Action Plan to Combat Modern Slavery. My name is Caskey and I look after the human rights programming at the UN Global Compact Network in Australia. And it's my privilege today to be joined by Director and Chair of the Modern Slavery Community of Practice, our Human Rights Workstream, and Founder and CEO of Pillar 2 Business and Human Rights Consultancy, Vanessa Zimmerman.
Thanks, Chris. Thanks for having me.
So, today we are talking about the UN Guiding Principles on Business and Human Rights, and as some of you will already know, Ness was part of the original Ruggie team who drafted the UN Guiding Principles back in 2010, 2011, was it?
2005 to 2011.
Oh my goodness, there you go.
Yeah.
And we haven't scripted this, and I'm putting this on the spot a little bit, but I am very keen to ask, and I've been meaning to ask this for a while, what was that process like?
I feel like we should have an hour to talk about this. The process was amazing. Really lucky to be part of an incredible team that had so many different types of people with different types of expertise. We had people who had worked in government, former diplomats, people who had worked inside a company, corporate lawyers, international lawyers, all working together to make sure that we were able to properly give guidance to business and governments on this very important issue. And of course, Professor Ruggie himself, who was a global expert in global governance and really able to see that big picture.
Amazing. All right, well, let's get into today's episode. So today we're looking at the UN Guiding Principles on Business and Human Rights. So I suppose just to take us from the top, Ness, what was the thinking behind them and what was the ambition?
I've actually brought my trusty copy of the UNGPs with me today because it's never far away from me, which is a little bit sad, and you can see it's a bit dog-eared. So the idea behind this document was to really make sure that a common language was going to be produced so that governments could properly understand what their existing duties were under international human rights law, but also what they could aspire to in terms of policy and legislative development. And so businesses could understand what their responsibilities are and start to get an idea of how they could actually implement them. So it was a really important document in laying all of that out. It's not a law, it's not a treaty, but it is something that is now being incorporated into various domestic laws around the world, regional initiatives, corporate sustainability initiatives like the UN Global Compact and more. So it's been amazing to see that growth and shift.
Fantastic. And this is something I wanted to touch on really briefly, and it's something that I've got wrong before. It's this cause, contribute to, or directly linked association test. What is it and how does that relate to the way that Australian businesses are looking to manage their modern slavery risks?
So we call this the continuum of involvement, and it sounds a bit fancy, but really what it is a way for companies to understand how they could be involved in an adverse human rights impact, which would include being involved in modern slavery, and what they need to do depending on their level of involvement. And the reason that it's there is because at the time, Professor Ruggie acknowledged that companies could be involved in human rights harms in different ways, including through their operations and value chains, and he wanted to acknowledge that there were different ways that could happen. The Australian government has actually referred to this continuum of involvement in the guidance for reporting entities under the Modern Slavery Act, and through that reference has essentially said that the way that you determine your modern slavery risks as a company is to figure out what you could be causing, contributing to, or being directly linked to through your operations and supply chains in relation to modern slavery. So it's a really important framework, again, to try and figure out how you could be involved in harm and what you need to do about it depending on that level of involvement.
Mm-hmm. I think we were going to go through a couple of examples.
We are, and what I'm going to do is essentially take you through the different parts of the continuum of involvement, give you a couple of examples where I'll tell you what bucket they fall into, and then we're going to put Chris to the test, everybody, and see what he comes up with when I give him a couple of examples, and we'll see how subjective this can be. It's not meant to be a legal framework where a company exactly knows all the time which bucket it fits into. Things might change depending on people's views or changes in facts, and you'll see how tricky that can get in a moment. So the first part of the continuum of involvement is where a company causes harm, and that is where the company itself does something that directly results in the harm. So if we were talking about broader human rights practices, it might be a company itself discriminates against an employee, or a company itself has an impact, let's say, on a cultural heritage site. In terms of a modern slavery example, let's say that a company A requires migrant workers to repay travel fees plus interest before they are paid their salaries and are told if they complain they will be denounced to the authorities. So in that situation, the company itself may have paid some travel fees for those workers. It's the company now that is withholding their salaries and saying that they will penalise the employees if they speak up. So the company there is causing the harm. Where a company identifies itself, and those words are really important, where the company identifies, not just when somebody else identifies it, but when the company identifies that it's caused harm, it should stop or prevent the impact and provide for or cooperate in remediation. The next bucket is contribution, and this is where the company has not caused the harm itself. It's caused by another party, but something the company has done or not done has been so significant that really without it the harm would not have occurred. So it's about enabling, facilitating, in some way incentivizing the harm, and that does need to be quite significant. So again, in the modern slavery context, a company A asks a supplier to reduce costs to such a level and with protracted deadlines that the company knows the other company may need to exploit workers to fill that order or might end up doing so. In that situation, because the company does know that what they're doing might have an impact on workers and they still go ahead regardless, there might be an allegation that they did contribute to that harm. Where that happens, it's treated in the UN Guiding Principles just as seriously as though the company has caused it. So the company, again, is expected to stop or prevent the contribution, use their leverage to mitigate any remaining impact as far as possible, again, provide for or cooperate in remediation, and decide whether or not to stay in that business relationship, which can be quite difficult where it's a crucial relationship. The third bucket, and where most companies will usually sit, is where they haven't caused the harm, they have not contributed to it, but something is happening in their value chain which still means they're directly linked to the harm. So again, in a modern slavery context, an example might be a company A sources component goods from a supplier B that bought raw materials that were extracted using forced labour from a sub-supplier. Did you keep up with that? Basically, what it means is that there is a situation where the company is buying something from someone who bought something else, and there was forced labour essentially that went into the products that were then going right up to the original company. So in that situation, the guiding principles do acknowledge that it's not the same as if you've caused or contributed to the harm. You're a little bit further away from it, but you are still expected to build or use your leverage to prevent and mitigate the impact, be able to show ongoing efforts to do so, potentially take a role in remediation. And we have seen some companies, for example, step in and repay recruitment fees that a supplier might have required employees to pay in other steps. And again, decide whether or not to stay in the business relationship. And if you do decide to leave the business relationship, to do so responsibly. So you can see that it is a continuum. It is something where a company can move from one area into another. And for example, if you're directly linked to harm, but it's happening for, let's say, 5 to 10 years, you are aware of allegations against the supplier that you're working with, and nothing is done whatsoever on your part to set expectations of that supplier, somebody might start to argue that you're starting to move into the contribution bucket because you haven't done anything for a number of different years. So we might move on to putting you to the test, Chris. Does that sound okay?
I haven't seen any of these.
He hasn't seen any of this. Let's have a go. All right. A company purchases print and packaging products from a supplier that is found to source timber used in the products from a sub-supplier that uses forced labour.
So the original company would be directly linked.
That's correct. Yeah. So in that situation, because the company, and if I gave you more information about perhaps whether the company has a supplier code of conduct or the expectations it was setting of its suppliers and sub-suppliers, that would have been more helpful information for you. But on this particular example, it is a direct linkage because it doesn't appear that the company that's buying the print and packaging products is actually doing anything to incentivize the harm. It's just that there is a product deep in its value chain that has forced labour in the production of that product. So it's a direct linkage situation. All right, very good. We did not rig this. The next one. A company hires a large group of apprentices who are all 16 and 17 years old to work at their construction site. The apprentices are told they have to work overtime 5 days a week and put in a high-risk area of the site without adequate supervision or safety equipment.
So I suppose that would be causing.
I agree. That would be causing. Because in that situation, the company itself has hired those apprentices. And for those that are familiar with the Modern Slavery Act, it includes the worst forms of child labour as a type of modern slavery. And the worst forms of child labour includes hazardous child labour, where somebody under 18 is doing work that might be hazardous to their health, physical or mental health, and in other ways also damage that child. And so this is an example, a potential example of the worst forms of child labour, and it is a situation where the company itself has caused the harm. Now you can't assume the next one's going to be contribute, so I'm just going to give you the next one and let's see how you go.
I was going to say next one's going to be tricky.
Let's see. A company awards a contract to the lowest bidding cleaning service provider who has recently faced public allegations for underpaying and mistreating migrant workers, including demanding to hold their passports for safekeeping.
So in this case, so company A, the original company, they haven't put in place any sort of supplier expectations, code of conduct or the like.
So that's a great question, which I haven't given you the answer to. So what difference would that make to this?
I think if they had have put those expectations in place and sort of, had that, as part of the, I suppose, supplier onboarding or the tendering process or something like that, they may, if there is an adverse human rights impact occurring with that cleaning company, they could move into direct link. However, the way it's currently set up, if they don't have any of those in place and there's an act and omission that may result in a adverse human rights impact, it's contributing to.
Exactly. And so in this situation, we know that there have been public allegations, so the company should know what has happened in relation to this cleaning services provider. If they haven't put anything in place at all to mitigate, to build the capacity of that cleaning services provider, they would start to move into contribute. If they had put more in place, you're right, they would start to move into direct linkage. This is why it's quite important for companies to really understand what mitigation steps they're taking and to know what might be expected of them if they don't take some of these steps and where they might start to sit in the continuum. So that was great. They were the 3 that I had. I could always do more, but I'll stop there. And I know that we wanted to talk a little bit about perhaps how things are moving along in this space. Over back to you.
Yes, so you mentioned a little bit earlier that the Australian government actually has the continuum built into their guidance for reporting entities that was previously ABF, now as part of the Attorney General's Department. Are Australian companies using the tests? And if not, why do you think that is?
So when we looked at the first round of statements that came out from the ASX 200, we actually saw that less than 5% of companies were actually drawing on the continuum of involvement to describe their modern slavery risks in their modern slavery statements. This has actually slightly increased with the last round of statements. So the statements that came out in 2022, we've seen a slight increase. What we've seen though is even for the companies that have started to reference the continuum of involvement, they rarely talk about it in relation to more specific risks. So they might generally say that they're using the continuum and what they understand it to be. But when they then talk about particular risks in their supply chain, let's say with particular service providers or goods providers, they're not really applying that language there. So we think that it is probably because there is still not enough understanding of what that continuum means. There are probably still concerns amongst legal teams and perhaps communication teams over what it might mean to say that the company does consider that it could be contributing or directly linked to modern slavery and what that might mean in terms of public disclosure. But we do hope to see more of it because it does send us a message that the company has really been thinking about how it could be involved and hopefully that it's driving its modern slavery risk management practices to really respond to that level of involvement.
I Thanks, Ness. That's extremely interesting. How is this popping up with other frameworks around the world? So we're looking at it in Australia as part of the Modern Slavery Act, but how are other jurisdictions approaching this?
So the continuum of involvement is actually popping up in all sorts of overseas frameworks, global initiatives, which is actually really good news for Australian companies using it, because it means they're, again, using a consistent framework that other companies, including their own suppliers and customers, might be using. So it is within now the new GRI human rights standards that were recently updated. So companies will be asked to report more on how they are assessing whether they're causing, contributing, or being directly linked to harm. It is within the new draft directive on corporate sustainability due diligence at the EU level, where again companies would need to show how they're assessing their involvement in human rights harm in accordance with the continuum of involvement. The OECD guidelines for multinational enterprises that I know a lot of Australian companies pay a lot of attention to. The current revision of those guidelines at the moment also continues to use the continuum of involvement to guide how companies are assessing their risks across a range of sustainability issues, not just human rights. So it is becoming quite common language and worth looking at what frameworks your company might be subject to and thinking about how you can increase your understanding of that framework.
Amazing. Well, thanks very much, Ness. That's been extremely helpful in starting to demystify some of those different criteria. And I'm very glad I was able to pass some of the tests. I was a little bit worried about this, but
well done.
There we go. Thank you all so much for watching. That's all we have time for today. If you'd like to learn more about the UN Global Compact, you can visit us at unglobalcompact.org.au. And we'll also link some of the resources mentioned today in the session in the description below. But other than that, thanks so much, Ness. We'll see you next time.
Thanks, everyone.
Sitting up straight. There you go. Shoulders
Ready?
back.
Yep.
Clap. You're like, which one? No, this was part of the original rugby team who drafted the God damn it, it's doing so well. As part of grant funding made by Australia. Why do I keep doing this? Why is it they one line?
Yeah, I'm just starting again because for some reason I decided to be very immature.